Thank you. So today, as we have heard from the previous session, what we are doing. Cindy, for the next 3 days, this is what we will be doing. So allow me, very privileged really, to introduce the panel that is before you today. Before I introduce them, let me just introduce myself very briefly. My name is Adeline Chelagat Kipto. I am the moderator for this session. For ground rules, please just don't walk out or walk in, especially when they are talking. Please put your phones on silent. Sawa sawa. And then let's just have an engageful conversation. Sawa sawa. So this is how the period will go. We shall have the first 1 hour, 20 minutes for the panel to discuss what they have prepared. Hii panel hapa wame prepare mazungumzo for the various articles, Article 20, from Article 19, 20, Article 23, Article 24, 25, and 26. They'll introduce the articles themselves. And then after the 1 hour, 20 minutes, we shall have 40 minutes for questions. Sawa sawa. So ukisikia wamesema kitu ambayo unaona imekushika ama uko na swali pali popote, please take down your questions and then we'll ask them. So without further ado, allow me to introduce the panel for today. Starting from my right, we have Miss Fortune Pawi, who is a fourth-year law student, who will be discussing the right to life. Second, we have Miss Evelyn Machoka, who is going to the second year, fourth year, who will be discussing Article 23 together with Mr. Joshua Kipiego. Next, we have Ms. Joyce Wambui, who will be discussing Article 25. And lastly, we have Mr. Lewis Ndichu, who will be discussing Article 24. And for our lead discussant today, I believe you guys have already met him, but allow me to just give a very brief bio of who he is. So Mr. Evans Ogada is a constitutional and administrative lawyer, a law litigator who has argued many cases in Kenya and the region, including the famous BBI case. We have the Finance Act case and the Haiti deployment case. He also mentioned in the previous session about you'll be arguing about the Boniface Mwangi case. So these are very many big cases. He's represented the Law Society of Kenya and appeared before the East Africa Court of Justice, as well as the African Court of Human and People's Rights. So beyond litigation, he consults on constitutional law. He teaches at the University of Nairobi, and he chairs the Rule of Law Committee at the East Africa Law Society. He's an editor, an author of several publications, and a trainer on international law, judicial independence, and access to justice. This is just like the tip of the iceberg of what he does. So he'll be the one who will be our expert in this panel. And yes, facilitating basically. So karibuni sana, and we are very interested to learn and engage together. Sawa sawa. Remember, please do not walk in and out during the session. At this point, let me hand it over to the panel for them to begin their session. Asanteni sana.
Good afternoon. I'm Joshua Kipiego. I'll be tackling Article 23 of the Constitution. Article 23 of the Constitution talks about the authority of the courts to uphold and enforce the Bill of Rights. Thank you.
Good afternoon. My name is Evelyn Machoka. I'm one of the co-authors of Article 23. In my view, Article 23 is the engine room of the Bill of Rights. If there are no enforcement mechanisms, then there's no need to have a right, because what good is a right if it can't be enforced? So Article 23 is what translates the abstract declarations in the Bill of Rights to your rights, to enforcement remedies. Thank you. I hope we'll have a fruitful discussion.
Good afternoon, everyone. My name is Paui Fortune, and I'll be tackling the right to life. And this is a special right to all of us because by the virtue of all of us being present is because all of us get to enjoy the right to life. And so my right basically, let me just give you a breakdown, has 4 clauses. The first clause, which gives everyone the entitlement to the right to be alive. The second clause, which provides for the beginning of life at conception. The third clause, which is the law against murder, with the exceptions of when it is allowed by law or by the Constitution, and the fourth clause, which is the law against abortion and the specific exceptions. So I invite you all to join us in this discussion, and I'm very excited to have all of you here. Thank you.
Good afternoon. Habari yenu. Mko salama. Haki za kibinadamu. What else is there to your life other than your right? Your right to be here. Then someone tells you you cannot be here. My article deals with why you're telling me not to be here. Yet I have a right to be here. If you need to walk to Rafiki, unataka kutembea mpaka Rafiki, mtu anakuambia usitembee. Katiba yetu inasema utakatazwa kutembea vipi. And that is my discussion today. Thank you. Lewis Moshiri. Ukinipata uko nje usiniite ule mtu wa limitation.
Good afternoon. I am Joyce Wambwe, as introduced earlier. I am co-authoring this Article 25 together with my co-author, who's Henry Molanda. Maybe he can stand and say hello. Yeah, thank you very much. Article 25 is simply fundamental rights and freedoms that cannot be limited. This has been a fortress in our Constitution. These are rights that not during a state of emergency, not by any situation can these rights be limited. How excited I am to have the opportunity to discuss these rights with you. To start us off, we are going to go to start with the introduction of Article 23 as we move along. Thank you.
Okay, back to me. Thank you. As I said, I'm Joshua, and I'll be taking you through Article 23.1, Article 23. So Article 23, specifically subclause 1, talks about how you can approach the courts when your right has been violated, infringed, or threatened to be infringed. Yeah, of specific thing, it's that the article uses the word threatened. In that, let me now go to Kiswahili. Inamaanisha kwamba right yako si lazima ivunjwe ndio uende kwa koti. Uko na the right ya kukaa uone maybe something is going to happen that will affect your right, then you can approach the court. That alone is a ground for you to approach the court. Then 23.2 talks about decentralization of human rights jurisdiction claims. Specifically, this is relevant maybe given the scenario that we were from an era where we only had 3 high courts that could enforce the rights. For you to enforce a right, you need to access the court, as you know that. And for you to access the court, they are only limited to 3 places. That's Kisumu, Nairobi, and Mombasa. So tell me, a person in there whose right has been violated, how will they maybe seek redress? A person who's located in Nakuru, a person who's located in Kampiamoto, a person who's located in Mount Elgon. You see, that was the problem that the 2010 Constitution came to solve. So it solved that by providing a requirement that Article 23.2 says there shall be decentralization of jurisdiction, the jurisdiction to hear human rights claim, by giving other courts the jurisdiction would like to hear such claims. And initially it was the High Court, but now it was decentralized magistrates court. Right now we have a total of 116 magistrates courts compared to the previous time where we only had three high courts. You see, that's a commendable progress. In that, I'm very sure right now we have a magistrate court in Nakuru. We have a magistrate court in Molo. We have a magistrate court in Mount Elgon, in Mandera. So anybody whose right has been violated or has been threatened to be violated can access that court and seek the remedies compared to the previous time. My fellow co-author will talk about Article 23.3, which talks about the remedies. Thank you.
Perhaps before I speak on the remedies, I would like to reiterate what our discussant, Mr. Evans Ogada, said in the first series of Avid Readers Forum commemorating Katiba at 15. Mr. Evans said that the Bill of Rights is both prescriptive and procedural. Prescriptive in that we all have shared values that we're not supposed to depart from. And procedural in that there are institutions and structures for governance. So our article, each individual has capacity to seek redress in the court, and our article gives the court the authority to enforce those rights. So the court is the institutional structure in place to remedy any violation or infringement of rights. On to the remedies. The Constitution provides a list of remedies under Article 23.3. And under that list, there are 5 remedies listed, but the courts have again and again stated that the list is not exhaustive. This opens leeway. It provides leeway for courts to innovate new remedies. So think of it like a magic box or a magic hat. When a magician removes a rabbit from the hat and it was not there. So it gives the judges, in this case, the judges are the magicians, who innovate new remedies to remedy infringements and violations. And with the changing times, that is necessary for our Constitution. Examples of these remedies that have been innovated by the Constitution are anticipatory bail, whereby previously we saw that the court was only reactive to rights that have been infringed. But from that, we see that now the courts are proactive to threats that your right is going to be infringed. And a case on this is Ferdinand Waititu versus Republic, where he went to seek an anticipatory bail before he was arrested. I think that's all for now.
And I'm guessing from your findings in your research, you will come to the same conclusion as I did, that your article is quite transformative, because we used to be in a certain era that was full of violations of human rights. And the only place that Kenyans would run to was our courts. So Article 23 is very essential, and it's very important because it has given our courts the power for us to go to them and to tell them, you know, my rights have been threatened. I have been told not to do this, and I'm allowed to do it. So it has been an approach that has been accepted. And it's interesting because, for instance, in the era before we promulgated our constitution, the courts were very shy. You will bring to them a claim and you will tell them, my rights have been violated. But then they will tell you, no, the constitution says if you have been told that you have been arrested because of public interest or due to public interest, then that is the end of it. We have had constitutional petitions and people taking claims to court, and they are being told, no, this is not specific enough. Some of you are old enough to remember Anarita Karim. She was vying for a seat, and she even had to drop her teaching in school, only for her to be told, Apana, Just go sit down and tell us what exactly are you saying that your rights has been violated? What rights have been violated? And it was very hectic. But now, out of that frustration, and most of us Kenyans had this burning desire to have a legal order that was structural and it was detailed. Tell us, if you're telling me not to speak out, if you're telling me to shut up, what are the reasons? So, and that is how we find that in our new constitutional order, we have Article 24, telling us that any limitation of a right has to be by law. Lazima ikuwe imekatazwa na sheria. Na si sheria tu. Ni sheria ambayo inakuambia this is exactly what you should not do. And it has to be accessible to you. Unafaa uko ukijua ni sheria gani, what actions have been limited. Second, this limitation has to be necessary in an open and democratic society. That means, see, your rights should not be limited simply because it comes out of convenience to do so. It has to be out of necessity. Ni lazima ulifaa ukose kufanya jambo hilo kwa sababu you are threatening perhaps the enjoyment of rights of others. But then what is interesting is how we have shifted. So from very shy courts to courts we have seen nullifying elections. Mnakumbuka in 2017, sindio? A very bold decision from our Supreme Court. And this has it has been happening. Our courts have been empowered by Article 23 for us to have a structured framework of limitation of rights. And not just about limitation. Unajua kuna haki ambazo huwezi nyang'anya. Hizo ni haki kama ambazo Joyce atakwambia. You cannot be lifted from your home. Uende utochariwe simply because it's not allowed. So we have moved from a very dark constitutional order and to a very bright one. And our courts have shown us that it is possible.
It is in that dark horror that Article 25 was born. Article 25 lists 4 specific rights that cannot be limited. Let me read out the rights that you may have a clear view of it. 25.1 clearly states that Article 25 states that despite any other provision in this constitution, the following rights and freedoms shall not be limited. 25A goes ahead to provide for the freedom from torture, cruel, inhuman, or degrading treatment or punishment. B goes ahead to list freedom from slavery or substitute, then the right to a fair trial and the right to an order of habeas corpus. These rights have historical backgrounds for them to be born. If you can permit me to take you through the freedom from torture. Torture is something that could happen anytime, any day. As Pawi will tell you clearly, right to life was something that it was enshrined by itself. Probably you're wondering why is right to life not here, but that is a subject that we will get into as we go deep. But freedom from torture, as you all have heard about the Nyayo chambers, and here is where what my friend Lewis has stated about public interest clause, which was actually in the Constitution, was a phrase that was used to allow freedom from torture to happen with no one questioning. When you go to court, now back then, before the 2010 Constitution, if you go to court and you present yourself and say, I was tortured, nothing much will happen because it is in the best of public interest that happened. And therefore, that was how freedom from torture was born. And the crafters of the Article 25, what they had deep down in their hearts was that we do not want human dignity to be taken away from you as an individual, life is not just life without its dignity. And therefore, we cannot torture you. We can't treat you cruelly and just torture you anyhowly or make you a slave. Probably slavery in the past is a whole different issue from modern slavery. And you can't just go to court and be given a clause without specific reasons why your case has not been dealt with, or even go to, when we look at the right of habeas corpus, let me bring it to a simple language. The right to habeas corpus is simply the right to challenge unlawful detention. I can't, as the law, we can't come and pick you and just detain you without any legal or laws background to why we are detaining you. And so that was a subject of discussion deep down in their hearts, that we have to protect these rights from being derived. And therefore, they drafted now these 4 articles that are fundamental to us. The reality of these rights is that currently they are being protected. Now, if you can permit me to take you to a case, how these rights are being protected in our constitution right now. There's a case that was Abhinav versus the Pose Farm Co. Limited. This case was in 2025, and what happened is a certain lady worked in this farm. Now the lady is called Abhinav, and when she was working there, the employer used her photo to advertise. And in this whole thing of advertising, they did not seek consent. Hawakuomba ruhusa ya kutumia picha yake kwa advertisement to advertise the company. So the company made profit with the ads and everything, but since they didn't seek consent and they didn't pay anything to Abhinav, it happened that she went ahead to present the case to court. And after presenting the case to court, the court said that this is actually infringement of freedom from slavery or substitute, because you're using me and you've not sought consent, and also you're not paying me. So that is an example of modern slavery. Yes.
Thank you, Joyce and Lewis. And I think I'll build on from whatever you have discussed to bring into light a question that has been on my mind for a long time, which is, why exactly don't we have the right to life under Article 25? So Article 25 gives us the rights and fundamental freedoms from which no derogation is permissible, right? And we have the right to life, which in real sense is the most important right, in my view. Because then if you are not accorded the right to life, how then are you supposed to enjoy all the other rights in the Bill of Rights? So let me paint a picture from the past regimes. So the right to life has been there in the 1963 Constitution and in the repealed Constitution. The problem was the number of limitations that were attached to this right. So for example, Section 71 and Section 15 of the previous constitutions would provide that you have the right to life, but then it might be limited for purposes of public interest. But then we are not told what public interest is. And because of this, we had a loophole which could be abused by the state, by the government, and the authorities to, for example, shun or shut down the voices of people who opposed them. So what did the people want when the current constitution was being passed? The people first wanted to be protected. They wanted a document that would protect them and would protect their rights. And that's why we have Article 26 on the right to life, 26.1 giving everyone the right to life. But then Article 26.3 provides a limitation on this right by providing that yes, you have the right to life, but then it may be limited by law or by the Constitution. Now, the Constitution does not go further to mention how exactly this right may be limited, but the law in question is the Penal Code, which provides for the death penalty as the punishment for murder. And many people will say, the death penalty is necessary because it will incapacitate the murderer, because it will deter the murderer from committing the crimes further. But then that same purpose would be served by life imprisonment. Because if you sentence someone to life imprisonment, you will deter them from committing the crime and you will incapacitate them from also committing the crime. So perhaps, Joyce, you could give us your opinions on whether you do agree that Article 26, the right to life, should be included in your article.
The right to life is a very important article in the Constitution. Ideally, in constitutional frameworks internationally, we have Article 25 being an absolute right, that it cannot be deprived from you at any moment. But in my own opinion, and Article 25 in Kenya has been interpreted differently. If I may take us to the Esmakonye case, which was in South Africa, they clearly stated in 2017 that death penalty is unconstitutional. And when we look at several other cases, we are able to see that life is not just life. Life is life with dignity. And when we are talking about life with dignity, and we incorporate the right to life under absolute rights, that will put a very huge burden on the state in protecting this right. Yes, we are doing constitution not for the state to work on it to be implemented, but for us as a community to make sure that we uphold the constitution, practice it, and make it a reality. When we say we want Article 26, that is the right to life, to be under absolute rights that cannot be limited, which I totally agree, it's okay to have it there. But now the issue that will come in is that the dignity of the right itself, will it be accommodated for there? That is a subject open for further discussion.
The question is interesting because it brings forth the question of what are other nations saying? You know, because this right to life, it's not for Kenyans alone. It's international. Okay, not international. Universal. Thank you. That's the word I'm looking for. Universal. So it means that even Tanzanians have the right to life. Even Ugandans have the right to life. So what is the framework, or what law binds this right to life for all of us? Because, for instance, when you come to limitation of rights, you'll find that we have certain instruments, human rights instruments. For instance, the International Convention of Civil and Political Rights, the African Charter on Human and People's Rights. So these are laws kutoka nje ambazo tunafuata pia, kwa sababu tunaelewa kwamba haki zetu si zetu peke yetu, si ndio? Kuna rights, we share rights all across as humanity. So when you come to the limitation of rights, what is acceptable standard is what we have framed in our constitution, and how we incorporated this structured framework. Zile points nilikuwa nawapea kuwa lazima sheria ikue imedhibiti haki yako, kuwa lazima ikue necessary, na it must be the least restrictive means that has to be opted. These are not just our own standards. They are national. They are accepted generally. So if you go to Uganda, you might find the same approach. Now, what we are wondering is, how far have we aligned tumeweza aje this far tangu tuweke katiba yetu ambayo, and you might remember that it was a call. Tulikuwa tunasema let us have a framework that is similar to other constitutions such as that of South Africa. So, and what I found interesting was that we have to some extent followed these international standards. For instance, you'll find that there's a decision by the Human Rights Committee. Hiyo ni koti tu kama ya hapa, lakini ina deal sasa na hizo sheria za kutoka nje. Sasa wao wanasema kuna watu wameenda demonstration pale Finland wanasema we want demonstration. Wamepiga kelele sana, lakini kuna bana wameweka pale. Askari anakuja anang'oa. You have made a statement and then they come pick it down. So the committee said that this is unacceptable. That was unnecessary. Haikufaa kuwa hivyo kwa sababu ule angeweza aje kujieleza kama umetoa ile bana. And then they went ahead to tell us that hii bana imekatazwa kwa sababu inatusi mkubwa. It was criticizing a public official. So they tell us, no, this is not how Article 12 and 21 of the ICCPR demands. We have rights, and this is not how we approach them. This is unnecessary. And when you come to our legal context, hapa kwetu sasa, we are also adopting the same principles. So we see, kuna mahali unapata kesi imeletwa. Koti inatuambia aje. It is unnecessary for us to tell people to stop saying certain things because we want to criminalize defamation. Nimekuja nimekutusi kwa sababu wewe ni mkubwa. Nimesema we kwenda. Nimekujiwa kesho. So it was unnecessary. Na hii kesi Joyfrey Andare versus the Attorney General wamesema hapana. It is unnecessary for you to bring in new laws that are limiting the same rights that we can find in other fields of law. Ukinipeleka koti unasema nimekutusi, nani ataharibikiwa hapa? Lakini ile saa una criminalize, you are criminalizing. It is open, unaweza ni kuja uniambie. Now it is open for arbitrary use. So to some extent we have acknowledged these international standards. So for you, what does the right to life mean for these other instruments? And how has it been interpreted?
Thank you, Lewis. And I'm glad you've mentioned things like the ICCPR, the United Nations Human Rights Committee. And I'd like to point out that both of them have commented on the right to life being accorded the non-derogability status. And by virtue of us being a party to the ICCPR, don't you think it's high time for us to comply with it? And also to Joyce's point on the applicability, I think, of Article 26 being included in Article 25, don't you think that the absence of the rights under Article 25 has caused more harm than good? For example, let me point you to the protests that have been going on. And so if you tell a policeman that you can use any other means to stop the protestants, but you're also allowed to take their life. From what we have seen from the story of Kennedy Onyango, the 12-year-old who was killed last year, from the story of Karaoke, who only had a bundle of masks that he wanted to sell to make a living, but ended up being shot in cold blood by the police, just because this right has not been decoded, that status of non-derogability. So to that, don't you think it has done more harm than good by being absent in the list under Article 25?
It has, but permit me to direct that question to our discussant, Mr. Evans, and as we take the next step. We have heard how Article 24 is explained globally and in regional context. Article 23, we will really love to hear about your international standards.
Okay, asante kwa this opportunity. Kwa this opportunity. Apoleni. So, as I told you, I'm talking about Article 23, and Article 23 vile tulisema ni article kwa constitution ambayo inapatia court the power, inapatia court nguvu ya protect haki zako. Wewe haki zako zikivunjwa unaenda court ina protect your rights. But sasa, giving reference to the previous, like to the first session, of where maybe one of the community members stood up to ask, then what's the essence of maybe like courts? If courts issue remedies, courts issue declarations, courts issue orders, but the orders are not met. That's hata nyinyi mkosho mkono hiyo maswali. Finance bill juzi court ilisema 2023 ilisema finance bill isiendelee, lakini serikali ikaendeleza. Court ikasimamisha housing project, lakini serikali ikaendeleza. In fact, president wetu William Ruto mwenyewe alisimama akasema ya kwamba kama utakuwa na decision ya court ambayo ina derail my activities, like my programs, then I won't respect it. So such things, hizi ndio vitu unaangalia, maybe the drafters of the constitution never foresaw such activities. Hapa ndio such provisions za international law zinaingilia. International law ni sheria ambazo zina bind nchi kwa states, mataifa. So Article 23 basically provides for appropriate remedies. Appropriate remedies are remedies that are given to that context. They are context specific. Venye my fellow discussant said, ukiendea court, uambie court, look, wameua mtoto wangu, nataka mnisaidie. Court haizi mrudisha, haizi fufua mtoto wako. But court itaangalia venye za kusaidia. Court inaweza angalia huyu mtoto wako angekusaidia maybe na njoo ni mzee angekusaidia na maybe matumizi, ikupatie maybe pesa fulani itakusaidia. Uende court useme shamba yangu imechukuliwa, court itaangalia itakusaidia aje. So inaangalia the appropriate remedy yenye inakupatia. Lakini one of the problems of these remedies is that currently ukienda court, kama one of you may access court, for your case to be determined, it can take maybe 1 year, 2 years. So acha niseme shamba yako inachukuliwa saa hizi, alafu uende koti, ombe koti nataka unisaidie. Lakini kwa sababu kesi ni nyingi, unapata kesi yako inakuwa determined after 1 year. So shamba yako imechukuliwa, na si ati kwa sababu koti imechagua hivyo, ni kwa sababu kesi ni nyingi. Mkienda kuna hizi vitu ndio mention dates. Mention unapewa once in a month, no, twice in a month. Ndio ni mention, hata hiyo hearing. So ndio koti ingie kusaidie upewe the appropriate remedy yenye unafaa. Unapata kuna kitu inaitwa overtaken by events, in that your remedy, the remedy that you to be given, ni kama sasa hiyo ya uweze lilia maji ambayo yamezoleka ama yamemwagika. Yeah, crying over spilt milk basically, as in kitu kama hiyo. Sasa those are the challenges that Article 23 faces, and maybe international law. International law provides for effective remedies. Effective remedies has elements. One element of effective remedies is that the remedies should be timely. In that ukienda koti leo, uambie koti shamba yangu inachukuliwa, koti inafaa iangalie the urgency of this matter na venye itaingilia kukupatia hii remedy ndio ikusaidie. Hakuna je kupatie remedy itoe orders after your activity, after right yako sema imekuwa violated. Unaona? You know, one of the things. Another thing is that remedies should be affordable. Saizi mnajua ndio uende court, uambie court your right has been violated, unahitaji wakili. Kupata wakili ni pesa nyingi. So one of the things that the constitution came maybe to solve is to provide pro bono services. Article 52, I think H, states that nyinyi mnajua unaweza kama tunasema mtu wako ameuawa na huwezi pata wakili. You can go institute a case, then the court will assign you with an advocate paid by the government. So those are the efforts that the constitution came to address, so that nyinyi mnajua hii Kenya pesa ni ngumu kupata. Sasa shamba yako imechukuliwa, okay, mtoto wako ameuawa, lakini kwa sababu huna pesa huwezi enda koti kusema mtoto wangu ameuawa, alipigwa risasi ama nini. Lakini sasa hapo serikali inaingilia, inasema wewe tuachie hiyo, tupatie kesi, tutapatia wakili wetu akufanyie hiyo kesi for free. Hizo ndio vitu inafaa mjue. Kuna pro bono services. Another thing about remedies ni zikuwe accessible. Venye nilisema, ndio uende access court upewe a remedy, unapata courts the very few. But the constitution venye ilikuja at that saizi kuna 47 counties. Kwa hizi 47 counties tuko na 47 high courts. On top of having 47 high courts, we have 116 magistrates courts stationed across the country. So wewe rights yako iko violated anywhere, si lazima utoke sijui wapi ukuje Nairobi ndio ufile kesi, utoke kwa kijiji ukuje wapi ufile kesi. Ni hapo tu unaenda una file kesi, kesi yako inasikizwa, malalamisho yako inasikizwa, kama ni kusaidiwa unasaidiwa. One of the things that maybe I'd like to mention about international law and Article 23, when nilisema international law ni sheria ya mataifa, ni Article 23 inasema ni authority of the courts to enforce, to uphold and enforce the Bill of Rights. Bill of Rights ni the Bill of Rights. So, with reference to Article maybe 19.3, because Article 23, hii constitution yetu huwezi soma kama, so unajua kusoma Biblia, huwezi soma Matthew na usome, huwezi soma Matthew peke yake na usisome Luke ama usisome, inafaa usome zote pamoja. So constitution yetu ukisoma Article 23 inafaa usome na Article 24, inafaa usome na Article 20, inafaa usome na Article 19, hivyo. Sasa Article 23 inasema in the Bill of Rights. Ukienda Article 19.3 inasema rights that are in this Bill of Rights are inclusive of rights in other instruments. Kenya tuko na constitution, lakini kama kuna right yako ambayo iko provided kwa hizi sheria za mataifa ambayo imevunjwa, hakuna kitu inakuprevent wewe kwenda court kusema right yangu imevunjwa kwa sababu iko kwa hiyo sheria na haiko kwa sheria ya Kenya, as long as it is in conformity with the Bill of Rights. Bora hiyo right yako hapo inalingana na the Bill of Rights. Na juzi kuna declaration, kuna a framework imetengenezwa na rais wetu, framework on reparations. Mnajua kumekuwa na maandamano, vijana wameuawa, hawa Gen Z and everything. Watu wamekuwa kilia, watoto wanauawa, hatupewi the compensation and everything. One of the things maybe unazoona international law ime influence such, ni juzi mwana president ametengeneza a framework for compensating victims of public protests. Even though imekuwa na criticism, but at least that's a step in the right direction. Another thing is that unaenda koti, when nimwambia unaweza cite hiyo international law. Maybe just to cite a decision, we have the gender representation case of 2012, where Mutunga, even though it's dissenting, but Mutunga used the provisions of the provisions of the Convention on Elimination of Discrimination Against Women to rule that 2/3 gender rule should be realized immediately and not progressively. Unaona, alitumia provisions za sheria ya mataifa kusema ya kwamba 2/3 gender rule, 2/3 gender rule, ya kwamba for decisions, for public making decision bodies, haikubaliki kisheria ya kwamba mkae pali fulani na mna make decisions that are concerning maybe the public, na mko watu wengi, inafaa mkuwe balanced. Kama wewe ni mwanadada, inafaa mkuwe pia kuna wanaume hapo ndani. Unaona, ndio kuwe balanced. Mnajua community yetu Kenya imetoka kwa nini yenye ilikuwa ina favor wavulana, maybe kuna communities zimekuwa nasema wavulana ndio wasome hivyo. So saizi ni inafaa balance. Asanteni.
Evelyn, it will be interesting. It's a very nice detailed explanation into the enforcement of rights and how international law has influenced that enforcement. So I'm also wondering, now that we have looked at what the history around the enforcement of the Bill of Rights was before we promulgated our constitution, and now that we have seen what international standards have required of us, where are we? Where are we in enforcement?
So, Lewis, to your question, where are we? Before I answer the question, I have to answer where are we coming from? So, our history in Zizaki Namoi, I wasn't there, but maybe one of the community members can tell us. So, based on my reading, our history was that the judiciary was not empowered. The judiciary served as the handmaiden of the crown. Then when we when we promulgated the 1963 repealed constitution, the judiciary then became the handmaiden of the executive. So judges.
When you say handmaiden, I'm lost. So handmaiden, I'm thinking delivery. Ndio. So they were they were furthering the ideologies of the executive. So they were used as a tool.
Yes.
Okay.
So judges walikuwa appointed, transferred and dismissed based on what the executive wanted. So judiciary ilikuwa influenced na politics. Even though there was Section 84 that gave jurisdiction to the High Court, it wasn't really, the High Court didn't really have the independence to redress violated rights. So as Pamba said, one of the main challenges we had was that access was limited. So in the previous constitution, throughout the whole country, there were only 3 high courts. So the accessibility of justice was limited. It was centralized. Then in the 2010 constitution, it was decentralized. Another thing was that the procedure was technical.
Okay.
So 1963 repealed constitution, there was a requirement that the Chief Justice had to make rules to guide the human rights violation litigation processes, which was not done until 2001.
Okay.
So that was also a problem. An example of that issue is the Kenneth Matiba versus Republic, where Kenneth Matiba took a petition to court due to the presidential elections. So he suffered a stroke and he could not sign the petition yeye mwenyewe. But the wife had the power of the attorney and she signed the document. But the petition was dismissed because Kenneth Matiba, who was sick, could not sign the petition himself. Another case was Moi Kibaki versus Republic, where one of the requirements to institute proceedings was to personally serve the respondent. President Moi was the respondent. And
there was no way to actually
successfully, the security detailed alizuia personal service. So the petition was dismissed despite the efforts. Those are instances of the issues we faced.
Okay. Now, I'm interested to know, now that we have as many high courts as possible, we even have the magistrates courts, what approach has been taken by courts, even after being empowered, to be the sentry, to be the guard for the Bill of Rights? What approach have they taken so far? Because I find it interesting that with limitation of rights, the court is quite progressive. And we have so many instances. For instance, just this year, Section 226 of the Penal Code was nullified on grounds that that is the provision for attempted suicide. It was nullified on grounds that it was proportionate, and also because they referred to international standards. So they're saying it's unfair for us to subject people who have mental health illnesses to such stringent law. And that was the whole ground for the nullification of that provision of attempted suicide. But then you also find that where we have controversial subjects, for instance, on the decriminalization of homosexual laws, it becomes a problem. Okay, not entirely a problem, because the courts are very particular about talking about conserving the moral order of our constitutional provisions. So what do you think? Is there still deference among judicial officers that is limiting how the actualization of Article 23 is seen? And this goes across board. Do you think that the judiciary, or is there a culture, a certain culture from the history that we've had? Is there a culture that has been carried forward? I would argue that it has. And our constitution is very transformative, but there are also certain gaps that have to be filled. So for instance, we have implementation. Now, this affects a lot the social economic rights. So that's a gap. If a law has been nullified, why is it still in action? That's implementation problems and political will to see the spirit of the constitution move forward. So I will argue that what I've seen is a culture carried forward of deference that the judiciary has maybe not entirely realized its independence.
I would also argue that the problem isn't entirely the judiciary, because the judiciary gives orders and state officers defy them. Which makes me throw this question to Mr. Ogada. If court orders are defied by state officers, is it a broken law or is it a broken promise? Because when we were promulgating the 2010 Constitution, the aspiration of the people was to empower the judiciary. And also, there's this saying by James Madison saying that if men were angels, we would need no governance. And if angels governed the men, then there's no need for internal and external controls. So, and also I would like to quote Mr. Ogada in the first Avid Readers Forum commemorating Katiba at 15, where he gave the story of the Ulysses Greek story, the man who said he should be bound by the mast of the ship. And Mr. Ogada argued that these provisions are there to curb violations. We are all human and we tend to be feral. So one way of, since we know we will be tempted to violate rights, then there's Article 23. So is it a broken law? Again, is it a broken law or is it a broken promise? That's my question, Hill.
On that note, as you have seen the progress for Article 23, Article 25 also has clearly had some good progress. And I'd like to take us to a case, which is Muchai and 5 others versus the Attorney General. This is a 2025 case. The brief facts of this case is that there were 6 women who were tortured by police like in 1992 during a protest. And they later went to court and petitioned that they want, they appealed, they went to the Court of Appeal and they brought it to the court that they were tortured. And the progress in it is that the court highlighted the fact that you cannot torture people, even if it's in the past. Like, this is something that we should note, that even if it happened in the past, you can still take it to court and it's petitioned and you are so like, now the remedy that was given to these 6 women is that they were given a cash bill of 2.5 M just to compensate the remedies, the damages that were caused, since they could not undo what was done then, but at least they were compensated for. Yes, that is the progress. And I can give my closing remarks from there. For Article 25, what we advocate for is let all of us protect the Constitution, let all of us ensure that our Constitution runs together, not as a one man's business, but as all of us business. Yeah, then I would like Article 26 to.
Thank you very much. And I think as my closing remarks, I'd just like to point out a progressive move by the courts. And that's basically with regards to my right, the right to life. The right to life does not only mean being alive or existing. It has been interpreted by the courts to in a manner that is connected to all the other rights. And so you don't only have to move to court to seeking redress of violation of the right to life when a person is murdered. It's not only that instance. You can also seek redress from the court with regards to the right to life when, for example, your social economic rights have been violated. And for example, if you have been denied access to healthcare, it will directly affect your right to life. If you're unable to access clean and adequate water, it will directly affect your right to life. So that's the takeaway that I would like the people to go home with. And for matters of the death penalty being abolished and the right to life being added to Article 25, I hope that comes into force. Thank you.
Huko Kabarak kwa mzee Moi. Makofi ya Nyayo. 2, 3. Asante sana. Hao ngono wamejaribu kadri ya uwezo wao kutupa mafunzo juu ya vifungu vya katiba kutoka 23 hadi 26. Vyaitwa vifungu. Niliona wengine hapo wakitafuna ulimi. Kiswahili kimeleta shida, mushkile. Ni kifungu ama kibambo? Haya, mimi pia natamatisha Kiswahili changu hapa kwa sababu nataka kuingia kwa maeneo ambayo imejazwa na kizungu kocho na itakuwa vigumu sana kutafsiri yale ambayo nitasema kwa Kiswahili. Kwa hivyo wazee wa mama wangu kutoka kwenye vikundi vya kijamii, tafadhali mtaniwia radhi kizungu kikishamiri kidogo, lakini kukiwa na shida mtaniona pengine pembeni nielezee kama kuna kitu kilicho wapita. Sawa? So essentially I must thank the panelists for going through a very difficult task, looking at each and every of these articles. That's a commendable task, and I thank you. Keep reading, keep researching. Now, as the future of law in this country, I want us to radically depart from status quo. I'm glad that my classmate, my brother, Dr. Harrison Mbori is here, and he will agree with that, because that is the way we were trained. If I'm lying, he'll say yes. But we were taught to have what we call critical thinking. I was told by, and I think Harrison was also told the same by the same teacher that taught us, Professor Mutungi, that a bright mind is not necessarily a lawyer. For you to be a lawyer, you have to have a critical mind that asks questions, prods, thinks through, plows the full depth. Don't take white for white, blue for blue. Ask questions. Tuko pamoja. And that is the message I will want to leave with you today. Because we have become a cliche society where we bandy words like transformative, progressive. We praise judgments here without asking questions. I was sharing with Dr. Mbori a few minutes ago that I was asked to look at a judgment from somewhere, and him and I, being students of international law, that would not fly in any serious law school outside the country. Yet we here in Kenya are holding it out as the marquee decision for some treaty. So in short, ladies and gentlemen, think, ask questions. Now, for you to understand the Bill of Rights and adjudication over the Bill of Rights, you have to understand the architecture of the court. Why do we have the High Court having the adjudicatory power, not power, sorry, but authority that has been granted to it under Article 165? Why is it that it was granted that authority? What form does it take with the authority in Article 165, read together with 22, 23, basically that authority to safeguard the Constitution? I want to go very quickly through a synopsis, and for a further conversation on this, I'll want to refer you to Charles Munger Fombard, Constitutional Adjudication in Africa. Charles Munger Fombard, Constitutional Adjudication in Africa. Read from page 18 of that text. When the court engages in looking at actions conducted under the Constitution or in the name of the Constitution, it is basically exercising a review competence. Now, in certain contexts, that will be called judicial review. And judicial review, so-called, means it's the court authority to invalidate laws or actions that contradict the Constitution. That is judicial review. In the broad sense, sorry. Then we have what we call constitutional review. Now, constitutional review, the court expands beyond legal interpretation to adjudicate on fundamentally political conflicts. That is why some of us went to court to ask questions on the Gachagua matter when he was impeached. And some people were telling us, no, this is a political issue. The courts have no business. When we went to court over BBI, they were telling us that this is a political issue. You have no business as the courts. No, when the court is examining political action, juxtaposing those actions against the Constitution, the court is exercising what? Constitutional review. I want you to look at the distinction between constitutional review, judicial review as argued by Fombard. Fombard again tells us that in certain contexts, the review exercise by the court is simply called constitutional review. Simply, whether we are looking at political action or we are looking at any other action that contradicts the Constitution, we simply call it what? Constitutional review. The reason why I went through that history is to pose the question to you. Do we still need a constitutional and human rights division and have also at the same time a judicial review division looking at the same folder, the Constitution? Some people like myself, my teacher and my friend, Professor Kech Migai, believe that the Constitution under Article 47 mandates that all forms of review should be under one court division. So this thing of judicial review division exercising some doctrines that sometimes don't match up to what the Constitution expects should not be there. Those of you who are writing your dissertations, that's a question for you to look at. Because as we currently speak, we have the review conducted under the Constitutional Review Division, Constitutional and Human Rights Division. We have a review conducted under Section 8 and 9 of the Law Reform Act. And then they brought in a further confusion the other day, Fair Administrative Action rules of 2025. You ask yourself, if we have the Mutunga rules that should deal with all items of the Constitution, including Article 47, why should we have a separate fair administrative action rules? It's a problem. So the future of law in this country, that's a question you need to ask. Another dichotomy that you need to look at in terms of you who is writing on this area is constitutional review being the weak form or the strong form. And in terms of systems, there are systems that have what we call the weak form review, and then we have those that have the strong form. So for example, in the UK and in Canada, due to parliamentary supremacy, they will conduct what they call a weak form because they defer to the authority of parliament. In countries like South Africa, Benin in Africa, they conduct what they call what? A strong form. In the weak form, the court basically looks at the decision, and its decision, the decision that is rendered by the court is not final. A subsequent act of parliament can overrule the decision of the court. That is the weak form. In the strong form, the decision of the court is final. And again, on that, I will want to ask you to consider when the court, for example, adjudicates and says, these are parameters of public participation in BAT. Can Parliament again go and sit and purport to legislate on public participation when the court has given us the parameters for public participation? Again, a question that you need to ask. Now, from a comparative perspective, again, looking at the High Court, there are two models of global models of constitutional review. We have what we call the decentralized, the American or diffuse model, the decentralized American or diffuse model. Then we have what we call the centralized or European model. The centralized model is what we have, for example, in Benin, whereby, and in France, not in France, Benin and in, is it Germany? Germany, yes. Whereby we have South Africa is decentralized, but it tinkers more towards the centralized model, where we have a strong constitutional court that declares a statement of finality in terms of judicial review. In what we call the decentralized or the American model, it's basically what we have here, whereby it's not one court that will declare itself on a judicial review question. For example, we have the High Court that can declare itself on a constitutional position. We have the ELC that can declare itself on the constitutional position. Again, the High Court can declare, but subject to overturn by the Court of Appeal and the Supreme Court. So that's a diffuse American model. Both systems have their merits and demerits. I want you to go and look at those in terms of understanding the authority given to us under the Constitution, especially granted to the High Court. Now, let me go to the specific articles. Article 23, and it's good I had contribution from the floor. Article 23 announces a certain principle. And the principle behind Article 23 is that justice requires effective solution. So you have to get a remedy when you go to court. And Article 23 is made within certain frameworks, and these are the frameworks that we all know: separation of power, rule of law, constitutionalism. So Article 23 is a representation of separation of powers. It's a representation of the rule of law. It's a representation of constitutionalism. I don't want to go through that, but whoever is writing on that, please go and look at it from those parameters. So Article 23 entrusts the judiciary with broad remedial powers, enabling judges to go beyond mere declarations. And the courts are required to fashion remedies that secure compliance with the Constitution. Now, from a separation of powers perspective, this demonstrates that the courts are not merely passive umpires, but are active guarantors of constitutional rights. So it goes to the question that I was asked. When the court gives orders, and some people think they are big enough to ignore them, you are ignoring the Constitution. And the court gives orders, this is what you need to do, you are ignoring the Constitution. And when you ignore the Constitution, you are in violation of the Constitution. You are violating essentially Article 1, Article 2, Article 3. Yeah. You are also violating Article 73, Article 75, Leadership and Integrity Act, and a number of laws. Essentially, you should go home. You should be fired. If you are not that state or public officer capable of being fired, you should be impeached. But as usual, what happens in our country? Yes, politics has overridden all else. That politics becomes a matter of life and death. We will undermine the Constitution at all costs. It is a problem. So that is Article 23. Look at it from a rule of law perspective, a constitutionalism perspective, a separation of powers perspective. Explain that from those perspectives. Then I go to Article 24 in terms of limitation. Article 24 is one area that we have been struggling with. The limitation of a right, and I will want to send you to an author called Gregor Weber. Gregor, not Weber, okay, Weber if you're English, Weber if you're German. He has written a fantastic book on limitation of rights, Gregor Weber. So simply, limitation of a right means that we are putting boundaries on how that right can be used. Yes, we have that right, but we are putting certain boundaries. Now, the usual way is to put limits and barriers to the exercise of these rights so that these restrictions ring fence for purposes of societal harmony, how these rights are understood. Now, I want you to look at Article 24 as a principal value in and of itself. And when you're looking at it as a principal value, again, I'm sending you to books. Go and read somebody called Robert Alexy. For you English speakers, it's Robert Alexy. Alexy is Alexy. And then we have somebody else called Mangabairo Unger, Robert Mangabairo Unger. He has also written on limitation of rights from a principal perspective. So as a principal perspective, Article 24 aims to realize certain values to the greatest extent possible. So that when you are engaging in Article 24 balancing, you are required as a court to realize the content of a right to the greatest extent possible, so that you don't derogate from its essential core. Now, what is the relevance between principles and the Constitution 2010, Article 24? Again, I will encourage you to look at Article 24 in terms of the principles. And if you want to understand Article 24, look at and read in its entirety the case of the state versus Makwanyane, 1995, South Africa Constitutional Court, whereby the court engages in an analysis of the balancing scheme so as to arrive at the test that we have today in Article 24. Because the court considered multiple factors, including the Oakes test, and by Oakes I mean OAKES, that was drawn from Canada. They also drew from German Constitutional Court jurisprudence. So basically what the South African Constitutional Court did was to look at the optimization requirements. Balancing and what we have in Article 24, what it is required to do to safeguard the content of certain rights. Balancing, how do we balance competing principles? Weighing, how do we weigh competing principles? I will encourage you to read that case. Now, let me go to 25. Again, the concept of non-derogability, that's a technical term. Basically, the non-derogable core argument understands that we have taken certain rights from the reach of the state, such that at no case whatsoever, even including in emergencies, would we allow for the state to limit any of those rights. So for example, in certain cases, we have what we call, we have the freedom of conscience, which is a non-derogable right in certain contexts. It is justified on the basis that there is a private part of you, what we call the forum internum, that the state cannot dictate. My freedom of belief, my freedom of thought, my freedom of conscience. Look at the non-derogability concept. When you are looking at 25, you'll be able to explain it. 26, finally. And I had this question explained. 26, the right to life can be looked at in several ways. You can look at the right to life through two themes: the right to life and the value of life. So the right to life, which has never been uniformly defined, it simply describes the natural and inalienable attribute. That's the natural life as we know it in the natural sphere. Then we have what we call the value of life. What does life stand for? What does it represent? I have written on this in my thesis when I was looking at the case of Njuguna versus Republic. It's quite an elaborate, owing to time, I'll not go through it. But for you to understand the political dimensions of life, which are represented by the value of life, and the philosophical, natural representation of the right to life, look at that so that you will understand why 26 is not part of 25. There are elements of 26 that can be argued to be within 25, but there are elements of 26 that cannot be placed within 25. Ladies and gentlemen, I know I was attempting the impossible. I have gone through a discussion of those rights. All you need to know is that don't take what you see on face value. Ask, interrogate. Don't forget the books that Mwalimu Mbori and others are giving you here. You will understand that to conceptually and philosophically understand the meaning and the import of rights. Thank you.
Thank you so much. Makofi Amoi. Asante sana. So much wisdom has been dispensed by this panel. The students have attempted to give history. where we are with the articles, what the future is. Mr. Ogada has elaborated, and I believe authors, you guys have benefited from the many books that he's referenced us to. At this point, I would like to open the question and answer, the plenary session. And we will have to end at 2 because our program was a bit late. So allow me to just ask 2 questions from the online, from our online people, and then we shall also take physical. Is it fine? So if you have a question, nimetayarisha, inua tu mkono, I'll come where you are and give you the microphone. So the first question is from Diana Obor, and which is a bit lengthy, but allow me to read it. You have to remember, so this is what she says. You have to remember that at the time of its writing, the new constitution received significant resistance from the Catholic Church and other religious bodies with regard to the recognition of abortion, Article 26.4. In the context of a more general precept, it would have been a tall task to make the right to life absolute. Also recall that this wasn't the first time Kenya had tried to pass a new constitution, 2005. Therefore, it was really important that the referendum does not fail. Perhaps 15 years later, we have the benefit of hindsight, but for now, perhaps consider what more can be done to enshrine this right. Okay, don't know if you understood it. Okay. So I think she's just basically asking maybe 15 years because we couldn't put the right to abortion basically in the constitution, but now it's 15 years later past. Is it maybe high time that we reconsider this? I think this is what she's referring to. We also have an anonymous attendee who asks, in the earlier session, one of the speakers appreciated the clarity of the constitution and said that what limits it is its application as a result of the culture of bad manners. For example, not obeying court orders, which I believe was Mr. Ogada. My question now is, do you think that there is anything that can be done to further aid practical implementation of the constitution and even court orders? So maybe I could refer this question to you. From our attendees here, let's just start from here.
Oh, thank you very much. I'm Cosmas Mutua, Director, Hope in Life, which is a community-based organization. And also, I work in the reproductive health space. So we've talked about the Article 26, this is right to life. So last week I attended a very interesting conference whereby we are discussing matters of obstetric violence. And there was a heated discussion about mothers who get violated during delivery to save lives. So it was controversial because sometimes the nurses have to use some bit of force so that the child, to protect the life of the mother and the child. And the discussion was that is violation, but sometimes I think it is some of us are alive today because of that small slap. Thank you.
Interesting question. And ensure that's just one question and you limit your time.
Yes, kwa majina naitwa Mwangi Muraya wa Nyambugi from Center for Enhancing Democracy and Good Governance and pia a member of Nakuru Human Rights Defenders Network. Na ningependa kufanya kwa Kiswahili kwa sababu nadhani mama yangu alinipeleka shule, yale yote ambayo nitapata pale nimuelezee kwa lugha ambayo ataielewa kwa sababu nimetumia hela zake na wakati wake. Niseme nimeshukuru mawakili hapa. Najua hapa kuna chama cha Kiswahili, najua mtakuwa mkitembea sana hapo. Mimi ningependa kuelezea ningependa kuambatanisha hizo haki ambazo tumepatiwa hapo, manake zitabakia tu theoretically kama hatutaweza kuzileta katika hali ya uhalisia. Sisi kama Human Rights Defenders tunapoenda kotini, na nitatoa mfano wa kijana ambaye aliweza kupotelea pale Game Park ambaye anaitwa Brian Odhiambo, madhara yake ya kuvunja ama kutofuata hii sheria ambayo tunasema hapa ya kuheshimu maisha. Ungepata estate ama vitongoji vitatu vimefanya maandamano siku 3, watoto hawaendi shule. Hakuna gari ambapo pale zinafanya biashara. Je, tunaweza kuambatanisha viongozi wetu waweze kujua tunapovunja hizi sheria za maisha, gharama ambazo fuata maisha yake. Hebu angalia maisha ya kila jenzi ambaye ameuliwa, kwenda mazishi pale, pesa ambazo zimetumika na hali kama hiyo. Na mwisho ningependa pia kuomba tuweze kuambatanisha hizi sheria na masuala ya kisaikolojia. Kwa mfano ukienda kwa Mama Brian utapata ya kwamba kila wakati huwa anazirai. So kutofuata hizi sheria zinatugharimu kifedha na pia zinatugharimu kisaikolojia. Tujaribu kuambatanisha na najua tutafanya kazi pamoja ili tuweze. La mwisho tu please. Je, ikiwa state mimi nikisaizi nikienda niue mtu, nitaambua nifanyiwe psychological assessment. Nayo state inapoua mtu inafanyiwa psychological assessment. Nadhani tukiuliza hilo, kuna wengine tutawapeleka pahali ambapo panafaa.
Wow, sugar. Okay, let me, Jenny, take this one and then we'll have this one.
Thank you.
Unapouliza swali, maybe unaweza penda kusema ule ambaye unataka ajibu hilo swali.
Thank you. My name is Peter Kimani from Center for kutoka kikundi ambacho kinaitwa Center for Transformational Leadership. And my question goes to our main facilitator, Ogada, and also my sister was covering the issue of Article 26, right to life. My question is very simple and maybe just a clarification of one of the characteristics of the human rights is that they are unalienable. And when you talk about the life, every human can only enjoy other rights when he's alive or she's alive. Then, Mr. Ogada, maybe you can make a clarification of like what my sister mentioned about the penal code. Can restorative justice work on the issues of maybe the judgment that can come out of the court in case of a murder? And then we bring the element of restorative justice. Thank you.
Thank you so much. My name is Harrison Mbori. I work here at Kabarak as a lecturer. I'm very proud of this moment also because of the wonderful students who have presented. I'll try to keep it short and sweet because of time. I have a fundamental sort of qualm with the use of terms. And this maybe is too lawyerly, but this is important. The Constitution does not necessarily use the word derogate, yet the courts and most of the commentators have used that word. The Constitution uses the word limit. And to me, there's a fundamental distinction that is very important between what it is to limit and what it is to derogate. And the idea of derogation mainly goes towards the taking away of a right for a certain period of time because of some issue, say public policy or state of emergency. So our Constitution foresees derogation, but the human rights framework as was developed does not necessarily have the concept. What we have is limitations. And therefore, Article 25, the rights are absolute. I agree with the commentator on Article 25 that those rights are absolute right, but they are not non-derogable. That is my issue, because a limitation is distinguished from a derogation. And once you take that distinction seriously, you will start seeing that. Finally, on Article 24, so these are just comments for you to consider. I have a big issue with the proportionality concern. Our courts do not have a specific proportionality framework. And again, this is legal, to some extent, someone might say legalese, but our courts do not have a proportionality framework. Even the Ox tests that my good friend and colleague Ogada mentioned has been imported but has not been applied well. And the Ox test, as you know, is borrowed from Germany, is borrowed from the European Court of Human Rights, then it is transported into South Africa, and now we are expected to apply it, but we're not applying it appropriately. The 4-part test on proportionality is not being applied. I have been scheming last week on all Supreme Court cases and have not found one on limitation where the proportionality test is then articulated and applied appropriately. And I think that is something for us to consider. Thank you very much, and I wish you all the best.
Thank you so much, Dr. I'm sorry, guys, because of the time, allow me to just give the microphone to one more speaker. I think I prioritize the community. Pardon? Oh, okay. Okay. Let's allow the lady, but let's take one. And then for the students, we will see. We'll see. Let's just have what?
Okay, good afternoon. Kwa majina naitwa Patrick Ngesa. Ninafanya na Shofco, Shining Hope for Communities. My concern is about Wanjiko. 2010 Constitution, tulitumia Wanjiko kupata hii Constitution. Na Kenya tuko na 3 classes. High class, middle class, and Wanjiko. Lakini ukiangalia hii Constitution, Wanjiko is not benefiting. Kwa sababu one, hata kama tunalaumu wanasiasa, but learned friend ndio wamejaa huko kama kina Ogada. Kwa hivyo hatuwezi tukasema ni politics, but learned friends ndio walitengeneza hii constitution na ndio wana violate constitution. Tuko na young learned friend, they are coming up. Lakini kule mashinani tumeshindwa, tutaweza anza wapi? Tunaanza na mzee wa kijiji, chief, na tukifika polisi kesi yetu imekwama. Tutafanya nini?
Asante sana kwa hilo swali. So we have the last person, and then the panel can try to be as brief as possible, as well as maybe infuse your concluding remarks, and then we shall end there.
Good afternoon. My name is Angelina Johanna. I'm from Midrift Hunet Network. My question goes to panelists who explained Article 23. My question is, how does Article 23 interact with other rights in the Constitution, such as the freedom of expression and the right to free trial?
Thank you so much. Yes, I shall now pass the baton to the panel. Maybe we could begin from this side, going this side, and then conclude with you, Mr. Ogada.
Thank you very much, Adeline. Perhaps to address the question on abortion, 15 years later after the promulgation of the Constitution, there has been a change. For example, the courts have interpreted the exception, the word used as an exception, health, to include both physical and mental health. And I see that's a change. So I think mine is to go back to the drawing board and include her views, and also Dr. Mbori's views on derogation and limitation, and see how I'll infuse them in my chapter. And also to thank all of you for being a part of this discussion. Thank you.
I would like to answer the lady's question. How does Article 23 interact with other rights in the Bill of Rights? So Article 23 is an overarching article. It provides remedies for all rights in the Bill of Rights, and also all rights that are not in the Bill of Rights, but in conformity with the Constitution. So if your right is violated, you have the capacity to go to court and seek redress, and you will be given remedies by the court. I think that's it. Thank you for listening to us. If you have any question for me, please nione kando behind the tent, not here. I'll be glad to answer you.
Okay, once again, good afternoon. So I'll be addressing, there's an issue raised about slapping of the women who are giving birth. So there was a recent judgment, County Government of Bungoma case versus JOO. So in that judgment, the petitioner went to court, a mother, caregiver, okay, a mother who had given birth. She went, the fact that is that she went to the hospital wanting to give birth. Then, as he acknowledged, I think it's something we are prevalent with in the society. Nurses, okay, so she wasn't attended to, which led to her giving birth on the floor of the hospital at the corridor. Then nurses came, they slapped her because of soiling the corridor of the hospital. So she went to court. And at the court, she met someone known as Kiagi. I think you're familiar with him. So Kiagi was like, children are very, in society, we treasure children, African society. A child being born is something that should culminate to a celebration. So why should you slap a woman who is giving birth? He acknowledged, actually, the same way he acknowledged, Kiagi also acknowledged this something that has been so, like, it's something that is prevalent in our society. And they adopted the provisions of the Convention on Elimination of Discrimination Against Women, African Human Rights Convention, and there's another convention, probably UDHR, probably. And they started the minimum core obligations. On the minimum core obligations, they said, you all know Article 43 talks about the right to health, socioeconomic rights, and it is subject to progressive realization, something Ogada said he doesn't like the terms. And the court said such provisions or such like right to health, especially for mothers who are giving the maternal, is subject to immediate and the minimum core obligations. So what I'm trying to say is that as much as he said without the slapping will not be born and everything, but it is to an extent. At that case, the nurses who did that and everything, they were told, I think, to pay 2.5 million to the petitioner, and the court laid out 3 minimum obligations for women who go to give birth. They should not be discriminated, they should not be verbally or physically abused, and they should be given the right to dignity like confidentiality and privacy. Thank you.
First of all, I first want to thank Mr. Harrison Buri for the comments. We have taken note. We will look on that as we continue to work on our chapters. And I want to handle the question that was brought forth by our friend, Mr. Patrick. And yes, the Wanjikos are the ones who probably are not in spaces where they can address themselves, as you have said. Mtaenda kwa chief awatume kwa polisi hatafikisha hiyo story ishe kabisa. Ikuwe ni, there's no a connecting line till to where the laws are being implemented and that kind of a thing. So, okay, let me comment on how Kabarak we are doing it. Here in Kabarak, we have a Center for Legal and Center for Legal Education, where we have an initiative of going to Mwananchi. Anyone who is out there and probably they hawana access direct to the courts or anything, ama au watu wenye hawawezi fikisha, like now sasa, kwa sababu hatuwezi rely on the chiefs, your line ni mrefu sana. Now, us as Clarkle, we are going deep into the communities to make sure that we are able to handle the communities as they are, trying to address their situations and everything we are doing. It's a new initiative, but watu wa community wameshaanza kuenjoy, and soon we will go deeper. Yeah, thank you.
Habari yenu tena. I am hoping we've had a fruitful discussion. Ninatumai tumekuwa nimekaa ni kama niko kanisa yangu peke yangu. I have been happy to have been your panelist. It's always wonderful to share ideas. So when we come here and put to the floor what we think is interesting towards growing our democracy, it's always welcome. And I am honored to be a part of this. Nimewashukuru sana kwa kuvumilia. Kutusikiza, it's very hard. Kukaa ukisikiza, it's very hard. I know because I sit in those seats every semester. Saa ingine unatoa umeiona mpaka karibu na majirani. Lakini you have to see it through because the benefits of it are just wonderful. So as we break, thank you all. And may we take this discussion even further. Hata tukitoka hapa, hatujaacha demokrasia yetu hapa. Sindio? Asanteni sana.
Asante sana. Kulikuwa na maswali mawili, I'll want to combine them. Uhalisia wa haki ya katiba kwa uhalisia wa haki na katiba kwa upana, ndugu yangu pale. Alafu kulikuwa na mzee wetu pale pia akiuliza maswali ya Wanjiko iko wapi. Ningetaka kuwapa changamoto kama wananchi wa Kenya. Tusafishe siasa yetu. Kwa sababu tukisafisha siasa kwa kupitia kura na kuuliza maswali huku mashinani, then tafuta mbinu mwafaka wa kusaidia afya ya katiba na uhalisia wa katiba. Kwa sababu sasa kuna michakato ya kisiasa inayoendelea. 1 term, 2 term, tukirudi kwenye debe tunapiga kura kwa misingi zetu za kawaida. Huyu anaongea lugha karibu na inayokaribiana na mama yangu. Then ukishampigia debe ameingia pale, anageuka kiongozi wa kiimla, dictator, na anagandamiza katiba. Kwa hivyo sisi pia tusimwelekezee Ogada na wenzake wanasheria mikono. Sisi kama wananchi wa kawaida tunafanya nini? Kwa sababu kuna wale wanatoka maeneo yangu na Mwalimu Otieno Mbori kule, baba akisema ni left ni left, baba akisema right ni right. Hauna akili ya kujiuliza, baba akiniambia left niingie kwenye mtaro, tutakuwa vipi? Tupige kura vizuri. Abortion haija kuwa outlawed completely. There is a narrow window of having an abortion under Article 26. Kusema abortion is outlawed completely, hapana. You can have an abortion, but strictly in accordance with Article 26. Which other question is remaining? Yes, I entirely agree with my brother and friend Harrison. Tunabishanaga sana, and I agree with him on this one. Proportionality, he knows. He spoke for me. Proportionality is not an English word. If you look at the origin of proportionality, and again, I want you to read Aaron Barak, former CJ, former Attorney General, former Minister of Justice, Israel. He has a book, 666 pages on proportionality. Read who else? I think Robert Alexi also has written on proportionality. Proportionality has about 3 limbs to it, conceptually. So that when you want to understand proportionality, sum the conceptual bit, then you read these other tests, then apply it. What do we do here? Mwalimu has said we are chaotic. Again, I want to agree with my classmate, my brother, Mwalimu Harrison. We conflate the two. There's limitation, which is restriction. Then there is derogation, which he said was what? Mwalimu wangu alikuwa amelala kwa class. Derogation alisema nini? Derogation is to temporarily suspend. And I believe that we can argue limitation and derogation within this constitution. So for example, in 25, you can argue limitation. Yes. but you can also argue aspects of it when it comes to Article 58 in terms of, because the state tends to suspend the whole of Bill of Rights. You can argue 25 in terms of its absoluteness when it comes to 58. So it depends with how creative you are on your feet, because you can also argue it from a human rights perspective, which we are allowed to argue when covering the Bill of Rights. Kohayo Mengi, may I say thank you. It has been wonderful being in Kabarak. I hope to be here in the future. Thank you very much.
Asante sana Mwalimu Ogada. I think at this point amekuwa mwalimu wetu wote. And to our panel pia, nimekuwa walimu wetu kwa leo. Tuwapigie makofi tena.